the smaller company side is healthcare. I think the amount of biotech M&A is usually a key driver in these upswings, and financing and funding and a bunch of the governmental things are providing huge headwinds to that industry. So there have been more biotech companies essentially closing up shop or returning their capital as opposed to getting sold. I also think that probably also been saying this for 3 or 4 years, but like the mid and small cap banks, I could easily see consolidation in this sector. So those would be the two I think have a lot of room to move up.
There's also the industries that have been like the sweethearts over the last year, like everything AI enabled, tech driven. Probably will continue to see growth in that space. I think similarly, because of the AI thirst, you have like the power companies or the utilities, and that I think we'll continue to see some interesting developments in the course of the year. And more than just industry per se, the other aspects that we are seeing, even in the activist discourse that we have been seeing over the last couple of months, are like, it's not even like an industry, but the breakup of like big conglomerates or big companies that are viewed as not being trading at the best multiple just because of like they're not specific enough or focused enough.
That's a great point, and we see the same. The amount of activist campaigns focused on breakups is huge, and some of this affects M&A as well. As investors get more and more focused on very specific pure play type of companies, it's hard for buyers to do deals that are far afield. It's like kind of middle of the fairway stuff with high synergies right in the area that they are core focused on are the deals that happen, and that limits the universe of potential deals. But this kind of investor obsession with pure plays is driving a little bit of that.
So David had another interesting comment about the fact that what you're seeing at Evercore is far different than what the markets and the league tables are showing, right? And so I think that bodes to our next question about private behind the scenes activism. So we have seen more and more private activism through the years. I mean, a decade ago, I think campaigns were much splashier. There was not as many constructivists, there was not as many engaged investors, if you will, and that's changed a lot. And so, I'd love to hear your perspective on any of the behind the scenes pressures, tactics, and any of the timing of these strategic reviews you've mentioned. And also, lastly, while you're talking about that, the selective outreach to the break of the conglomerate or, the potential deal at hand, how is that working and what are you seeing?
Yeah, great question. I think, look, the private behind the scenes activism is happening. It's always kind of happened. I think it is escalating, especially among certain funds, but there is still plenty of kind of hit you in the face with a fight deck right off the bat. So I do think it's both. I think one trend on that front that we're seeing a lot of is the private nominations of directors. There's many of these activists who sometimes I believe don't actually want to go to a fight. Probably a lot of activists don't usually want to go to a fight. And it is especially true with a smaller one that may not want to spend the money on a fight. So to apply pressure to the company when they're not gaining traction just in the suggesting, why don't you do this, why don't you do this, and the company's saying, no, we've thought of that, we don't want to do it, they put forth these private nominations, and it's a tricky spot for these boards to be in as they think about how real that threat is. Because calling the bluff could be very risky, especially if some of these companies are in a weaker position. But we see a lot of that. And then on the pushing for strategic reviews or kind of selective outreach to potential buyers, that's increasing, and I think that's good because activists are recognizing that a company coming out and putting itself up for sale with a public announcement that we're reviewing strategic alternatives is an incredibly risky position for the company to be in. You better be absolutely sure people are going to show up and you're going to be able to find a deal. If you make that announcement, you're going to have turmoil at your company, you're going to lose a lot of good people, and then if the deal never materializes, the stock's going to crater and your company is going to be weakened. So I think when we get activists coming in and pushing for that, and it's something, let's say it's something the board was already considering or already planning to do, we will 99% of the time encourage some kind of private process as opposed to announcing something publicly, particularly if it's pressured by an activist. Very few boards want to do that.
Yeah, and on the private activism side, I think the other aspect that's interesting, and you kind of alluded to it, is
the fact that we're seeing more funds, right? And like a lot of funds are spin-offs or alumni from like the big players. And as you mentioned, maybe they don't want to spend the money into the big activist campaign, Proxy. It could also be that maybe the times are changing a little bit and not everyone necessarily wants that like limelight, and they rather work in a little bit more of a collaborative at times perspective. As we were talking recently, constructivism maybe is making a comeback. But they will like pull up their gloves as necessary and are not.
Yeah, I think that's right, and I think that's also why you're seeing more of these kind of very small settlement things, where it's like you may not even sign a settlement agreement, but the company puts on, one independent director that they already kind of liked, that the activist then supports. For one of these small upstart funds, they can market that as a win, right? And they don't have to go through all the brain damage. They can look constructive with it. This isn't us, flame throwing, calling for some huge levered buyback or sale of the company. And we're seeing a lot more of that. And that's, obviously a positive trend from my perspective.
And it's also the shareholder. When you talk about the shareholder perspective and the passives, that's what they like to see, right? They don't like to see management's time and the board's time taken away from their day jobs, but they like to hear about this collaborative approach. And so I think as the passives are growing, it was inevitable that this approach happens. So, John and Francisco, we'd love to hear from you guys. If you were advising a company going through a private activism situation, how would you tell them to respond?
Yeah, I think the most important thing is to engage with your shareholders, right? And the activist is your shareholder, and we should not forget that. So that's point A. We would encourage you to talk to them, but it is important when you do go to those conversations, first and foremost, that you take into consideration Reg FD, and you're not providing any MNPI, material non-public information, to them, or to the extent that you do want to provide that, obviously you would have to enter into an NDA, which, by the way, the activists may not want to enter into because they're going to want to be able to trade on their information, or maybe they'll add you to the clients.
Yeah, I mean, the other thing that I would just add to that, and this is maybe a little bit different than the engagement with the activists in the private context, but it's sort of preparing for that eventuality. I think that every company should really be spending the time during peacetime to be making friends with the big institutional investors and just getting to know them, because nobody wants to make a friend when they need a friend. And so it's always good to sort of have those long established relationships, because when Evercore comes calling, and it's helpful to have a better understanding of your shareholder base. And we can talk a little bit about how some of those dynamics are changing. We probably will talk about those. But just being as preventative, an ounce of prevention is better than a pound of cure, in my opinion. And so being as prepared as possible, having good relationships, and also being open to the conversations. At the end of the day, these are your shareholders. The activists can have some really constructive, interesting ideas. Be open to them. Don't just sort of stiff arm them, because that could be very problematic. And I think that the perception of large institutions is there are some really good ideas that are being brought by the activists. So you better be listening to them, because sometimes they are shaking things up in really productive ways.
And let's not forget that the activists can also speak with your other investors, and they probably are speaking with their other investors, and they know them as well, if not better than you do, right?
Yeah, it's a much more repeat game for them, and so they know everybody. You might hear from the activists once every couple of years if things kind of that way. They're talking to the same folks over and over and over. They've developed rapport, they've developed credibility, and so you just need to be prepared for that eventuality.
You talked about a couple of different tactics, John. How would you think about an issuer, company, or client of yours potentially front-running the activists and going ahead and taking credit publicly for things that they've already been doing potentially in the background?
So, I mean, it's a big strategic consideration. For the most part, a lot of companies are considering a lot of these different things. And sometimes they feel like their hand is tied behind their backs, because they're like, well, we're going to refresh our board, and now we can't really talk about how that was in the works. So a lot of these settlements, a lot of these conversations are giving sort of sleeves off the vest, if you will, things that they were already going to give and give them credit for. And sometimes it's okay to let the activists take credit for something that you were going to do anyway. That can sort of lower the temperature, It can show that you're listening to your shareholders. I think your institutional investor base likes to hear that. That being said, it's not always going to solve the problem. You may actually really need to be listening to what they're saying and make some changes that they're suggesting. So it's not a panacea, but I would also just suggest that every company, every public company, be proactively thinking like an activist, like do a real self-inspection about like what are the deficiencies of the company. Of course, performance is probably the first and foremost. I mean, there's only so much you can do about stock performance, but there are certain things like get your governance in order. Yeah, tenure. Just really make sure that you're thinking through what are the vulnerabilities that we have, and try to refresh our board. Think about the tenure. Think about overboarding. Think about how the directors are or are not fit for purpose for the board, because an activist certainly is going to break those points up. So just try to be as proactive as you can, and be willing to give the credit to the activists if you need to in order to kind of make peace.
Yeah, and what I was interested in that question was like, are you thinking about it from the perspective of like, okay, I'm entering into a settlement with the activist, and in the settlement, obviously, we're going to put a press release, and do we want who needs to take credit here? Or are you thinking more of like, no, I'm not even engaging with the activist, but I'm basically going to say that, yeah, we're doing a strategic review, or I'm going to say like, we're refreshing our board like 2 days after activist told us to do that?
Well, I think both. I think that, well, I mean, you're probably going to touch on this, but I think a lot of companies are questioning whether they're going to lose their own credibility if they acquiesce to any of the activist demands. And I think it's a fine line of, managing expectations and making sure your narrative is succinct and getting that message across to shareholders.
Yeah, that's exactly what I was going to say, Christine. I think it is, boards absolutely hate when they're already considering something, already planning something, and then an activist jumps in and demands it, so now they look reactive, right? If their other shareholders are thinking like, oh, this thing that we all wanted you to do, it took this activist prodding to get you to actually do it. That sucks, right? So we had one client probably 5 or 6 years ago, industrial company, who had, very contentious, private, behind-the-scenes discussion with an activist, back and forth. They had all this analysis. They were kind of typical activist playbook, like crank up the buyback, cut costs, break up the company, add new directors. It became very clear that they were going to go public at some point. It was obviously inevitable. The board decided to preempt it and went out at their next earnings release, which worked out well timing-wise. We didn't have to do a standalone press release on this, and basically said, we're doing a comprehensive review of all, financial, strategic, operational opportunities to create value. Something that was kind of not the code word for a sale process, but was kind of covered all the gamut of all these different things to show we're looking at all this stuff. So then 2 weeks later, when the activist came out with their fight deck, it's like, yeah, we just told you shareholders we're already looking at this stuff. And it was perfect.
Yeah, the messaging is complicated at times though, right? Because it's so generic that then your investors are like, okay, but what?
Right. And you got to be carefully scripted on that and talk about some kind of specific things that you're considering and steer them in the right direction. But the key for the boards a lot of times is put that stake in the ground that we're looking at this stuff. And then when it comes up, it's like, yeah, we'll consider those as part of our ongoing review.
And I think that circles back to what we were talking about regarding that the potential of putting yourself up for sale publicly and then not having anyone come to you and, ask to look at your data room or have any interest. And I think that is what a lot of companies are terrified of. And so the way that you're wording it in order to make sure that the messaging is succinct and, you're carefully crafting it, I think that matters in these situations when they're high
I agree.
stakes.
That's the last thing you would want to do, like make it sound like you're actually just going to sell the company when you don't know.
Yeah. So I think we're going to switch gears a little bit now. We've talked a lot about M&A, activism, and now let's push to the legal side of things, which is, I think, why everyone's here. So let's talk about the new 13D and 13G rules. I think everyone has probably heard of the updates, and now we're going to kind of dive a little bit deeper and understand what it means for all of our clients. So I guess at a high level, John, how has the engagement process changed? And how are passive investors voting according to the changes?
Yeah, so just for background, for those of you who don't follow what goes into 13D or 13G. So 13D is typically the filing requirement for an active investor. If they have a thesis that will sort of promote change at a company, they will file a 13D, assuming that they meet the thresholds for ownership. 13G, on the other hand, is something that is leveraged by the institutional investors who are traditionally "quote unquote" passive. It's a much lower burden for them to make these filings. It's something that the BlackRock's, Vanguard, State Street's, the large institutional investors all do, and it's kind of ordinary course. And they do thousands of them because they hold every company because they're index funds. There was new CD&I that was issued under the new administration earlier this year that basically stated, if you are exerting influence, you should not necessarily get the presumption that you have this sort of 13G kind of safe harbor, if you will. That has changed the game potentially for some of these large institutional investors who now are kind of freaking out because, and this is in some ways a response to the blowback on the anti-ESG movement that has sort of taken shape in the last year or so. There's some concern that these folks who have been saying things like, you need to have X number of women directors on your board, or we expect you to have climate targets for the company, or else we will vote against your chair of X committee or what have you. Now those type of things that were largely protected behaviors that still allowed you to have 13G now could force you to have 13D under the new guidance. So that has potentially changed the game, and that has made a lot of the institutional investors, the large ones, a little bit more reticent to tell you what their expectations are when it comes to shareholder engagement. So a lot of companies have engagement leading up to their annual meeting. Maybe they're talking about like a contested situation, or they're doing off-cycle engagement, and they're just hearing about what these large institutional investors care about beyond what's in their voting guidelines. Those conversations were very much a two-way street for the last few years. You could have a conversation, they say, like, well, we like what you're doing here, we don't like what you're doing there. And the implicit thing, and maybe sometimes even explicit, was change it or else we'll vote against you. Now they're no longer able to do that because this 13G safe harbor is no longer necessarily welcome to them. That is potentially changing how shareholder engagement is looking. It scared a lot of folks when these rules first came out. Vanguard and BlackRock actually halted in off-season engagement temporarily just to kind of figure out what they're doing. I think that the new normal now is if you're at a corporate issuer, you'll still have these engagement meetings. You'll probably hear them read a script saying, we are not intending to be activists. We are here to just sort of listen and hear what is a priority for you at the company. So I think that the engagements have somewhat moved back to the way that they traditionally were run. However, I would say that the large institutions are much more in listen mode. They're not sort of showing their hand as to how they're viewing things. So I think it's potentially going to lead to some vote outcomes in the coming years that are a little bit more opaque. It's going to be harder to unpack. And then you sort of couple that with all the other macro pressures that are, befalling the proxy advisor community, the ISS and Glass Lewis. So there could be some changes. And so it's going to be a little unclear how these votes are necessarily going to be rolling out. And then adding an extra layer of complication onto that, within the large institutional investors, especially the big three, they're actually now starting to bifurcate their ownership. So the active side of BlackRock and the passive side of BlackRock may actually have a different engagement team that's engaging with you, and they may vote slightly differently. And so every company is going to have a very fact-specific analysis to understand how much of my holdings is held by one of these large institutions in an active side versus the passive side. And that could change vote outcomes. So it's a new world where we're kind of playing through. It hasn't fully borne out in this last proxy season, but this is kind of a foretelling of what the future is going to look like. And so I think it's going to potentially change the game for engagement. I think that the activists are also going to get wise to the fact that now they need to be thinking about these engagements a little bit differently too. So it's just a new change, and I think this is kind of the macro levels of uncertainty, and so that's just something to keep an eye on.
What I find really interesting from it is that from the activist perspective, they're going to have like an information asymmetry advantage in the sense that probably an institutional investor and the activist may have a little bit more candid conversation than the institutional investor and the issuer.
Yep. I think that's probably right. They're probably a little, they have to also then be careful around like
not
sort of
forming
like
a group, but like they're going to be very careful about that.
Yeah, that's a bar that they're very sensitive to, and they're not going to cross that threshold. But I agree. I think they can have more candid conversations, and I think now that some of these large holdings will be potentially voted by the actives within the index funds or within the institutional investors, could make some of the financial arguments a little bit more resonant than maybe some of the things that were purely E, S, or G focused, because I think that's what was leading the conversation in previous years.
So it seems anecdotally, it seems that in the beginning, the conversations were halted and now there's a script involved, but it's more to back to business to usual.
I think it's generally back to business as usual with the caveat that I mentioned that things are changing and it's a little unclear how this is ultimately going to play out. But I still would advise all public companies to be proactive in your engagements. You might get a little bit less out of the investors than you were in previous years, but that doesn't mean you shouldn't continue to have these conversations. And as I mentioned at the beginning, developing the relationships is critical no matter what, even if the conversations aren't as transparent as maybe they once were.
But you can still read the room.
You can read the room, exactly.
So it's important to continue to do it.
I would say from our experience at least, and we're in kind of like prime outreach for these off-season meetings right now. So like we recommend all our clients do this. I think that's absolutely the right advice. We're seeing the same receptivity to taking the meetings as we've had before. So from our perspective, at least, there hasn't been a downshift in their willingness to meet. It is just the content of that meeting is slightly tweaked, to John's point.
So we're going to shift focus a little bit here. So beyond the engagement landscape, there's also other forces that we're seeing reshaping dynamics. So I'm going to go to Robert now. How do you see the antitrust environment influencing M&A and activism going into 2026? And how do you want to think about everything we've kind of put out here today?
Yeah. Well, two things, and I think both of them kind of dovetail with the kinds of things we've been talking about today. I mean, the first is just on the trends. I think a year ago, the thought was that antitrust policy with the new administration would be more predictable and more M&A friendly, and that activism would follow from that. And so I think there was some exuberance going into the year that hasn't really been borne out statistically. I think, you look at the first couple of months of the year, it was a little bit down, kind of flat, and then leading up to and after Liberation Day, you get a big, like 70% drop in campaigns. And so any thought that, we're going to have an uptick was not borne out. But I think that tells the tale, right? That it is not antitrust related, right? It was different kind of uncertainty in the M&A environment, and I think you can still take the kind of broad view that where M&A goes, activism is going to follow, and those trends are probably going to be borne out. And so the question was, where does this go in 2026? And I think we're a little bit back to where we were last year in the sense of, I think there's a little bit more certainty in the other areas, and then maybe we get a bit of a bump from the antitrust policy in this administration. So we'll see. So that's the first thing. The second antitrust activism overlap point that I see of significance is the Texas versus BlackRock suit and what's going on there. So that's the case where Texas is suing BlackRock, State Street, and Vanguard and alleging that they acted as what they call an investment cartel in a scheme to force coal companies to lower output and raise prices. And they did this through things like joining climate-focused groups together, making similar public statements, and voting similarly. So the suggestion is that they're doing this not only out of the goodness of their hearts for some social cause, but also for to drive up coal prices and have an antitrust benefit. And they survived a motion to dismiss on this claim in August, which is obviously raises a lot of interesting developments in the activism space. One of them, though, that I think overlaps with what we've been talking about is that one of the arguments that the defendants made was that under Section 7 of the Clayton Act, there is a defense for passive investors. Passive investors can't be liable, so they argue that they were passive investors. Right? They weren't doing anything drastic. They weren't seeking board seats. They were acting kind of traditionally, as we've been talking about, as passive investors. And the court rejected that argument. It held that under the Clayton Act, any attempt to, quote, use your stock in order to affect change that could be seen as anti-competitive, and that's what Texas is alleging here at least, would make you an active investor for purposes of the Clayton Act. So I think it's interesting to think how that's going to dovetail with the 13D, 13G changes. May put extra pressure a bit on the institutional investors to, restrain themselves into more passive things. My read is that it's too early to tell. I would be careful about overreading this. It's one district judge in one case at the pleading stage. So I don't really expect a huge change based on that, but I think it's something to watch and something to see if that plays out in other cases throughout the country, and the pressure on that kind of thing could mount a little bit.
So moving past antitrust issues, have you seen any upticks in proxy fight litigation or how that's playing out in practice? And then taking it a step further, other than the Texas situation, how are courts evaluating new defensive measures that companies might have put into play this past proxy season?
Yeah, I think there's been a bit of a downtick over the last year. So in July 2024, the Delaware Supreme Court came out with its Kellner decision, where it clarified how it was going to evaluate defensive measures, clarified how the standard was going to apply. And I do think the clarity has had some of its intended effect, if people have been able to read that and realize what's going to be allowed and what's not going to be allowed, and that has slowed a bit the flow of activism litigation in Delaware, at least. The main case that has come out was the Ionic Digital case. It's a crypto company which had come out of bankruptcy, and so the creditors of the former company that become stockholders were pushing for the company to go public, and when it didn't, they launched a proxy campaign. They submitted nominations, which were rejected. And they were rejected on two grounds. One of them is, hey, you submitted 2 nominations, but unbeknownst to anybody, because we didn't disclose it, we reduced the number of seats up for election this year to 1 by eliminating a board seat. And the other is that you didn't disclose all of your agreements that are required under the advance notice bylaw. And the court found that the board reduction was a defensive measure, and it found that invalid. But it upheld the rejection of the nomination notice, finding that it had a pretty strict reading of the advance notice bylaw, pretty strict reading of what agreements you have to disclose, somewhat of a company-friendly reading on that, but it gave the stockholders a do-over based on the inequitable conduct. And so where all this lands, I think, is that where we're at is that any kind of true defensive measure is going to take a really hard look. And so I think you can see it really as kind of the cloudy day, clear day distinction. If you are enacting something where there's a known activist in your stock that's agitating, or a campaign has been started, it's going to be few and far between of those that are upheld. On the other hand, if you're updating to the latest generation of an advance notice bylaw or a rights plan, just in peacetime on a clear day, I think you're fine, and Delaware's going to hold it, and there's a little bit of clarity there. So my advice to public companies would be, institute that kind of a review on an annual or regular basis. And, be looking at your governance documents and have somebody say, do we have the latest generation of these things? So they change pretty regularly what the latest generation is, what best practice is. And if you update it before somebody's in your stock, it can be a strong defense, even if, there's other corporate benefits to it as well.
That's really good advice. So from that perspective, you mentioned Delaware a couple times. Do you ever advise clients, Francisco, to re-domicile in a different, friendlier environment if these kind of court cases are coming up and these are the verdicts?
Well, it's an interesting thing, right? There's been a lot of press about it, mostly deriving from Musk's dislike of Delaware. I think that moving out of Delaware, I don't really think you were seeing as much as people make it seem like it's happening. There are a few reasons why maybe you want to move out of Delaware, and the main one is if you're a controlled company, there's going to be jurisdictions that make more sense, specifically Texas and Nevada. So we're going to talk a little bit more later, but on the Texas front, there's been a lot of developments in order to make Texas more business friendly, more, and then Nevada just basically doesn't have the same levels of fiduciary duties. But Delaware has all this jurisprudence, all this knowledge that I continue to think it will just hold strong. And to the extent that the judges may become a little bit too not investor friendly, you have the Delaware legislature that quickly acts upon it, right, and tries to correct course, kind of what happened with SB 21 earlier this year, right? They basically said we need to clarify when entire fairness will apply and not, and how we'll deal with control shareholders.
Yeah, they're not, the Delaware legislature is not unaware of the market developments, and they don't want to lose their sort of monopolistic view or sort of hold on corporate incorporation. So they will react to what they're seeing. And so if there's some push coming from Texas or Nevada, you'll likely see some reaction to it to be seen as a continued favorite place to domicile.
So you brought up Texas. That's interesting. So Texas is obviously trying to reposition itself as a more corporate-friendly state, including not only taking on investors, but taking on the proxy advisors, it seems. What does everyone on this panel make of the new Texas Stock Exchange and their corporate governance standards?
I think let's start with Texas first, and maybe we talk about, like, in general. What they've done is that they have basically made the business judgment rule like the standard for Texas incorporated companies. They have created the Texas business courts. I'm sure Robert can tell us a little bit more about it, but they're generally viewed as more savvy, and they're really trying to make them look more like a Delaware type of chancery with like educated judges. They've also have done some interesting developments with respect to their derivative lawsuits, requiring higher percentages of stock in order to minimize the lawsuits. And then lastly, as you mentioned, like they're going against the proxy advisors, which has been an interesting development, I think. Yep. And John, I don't know if you want to talk about that.
Yeah, I mean, I can just speak real briefly. There was a recent law passed, and it was SB 2335, don't hold me to the number, and basically was saying that if you are making recommendations that aren't necessarily fully pecuniary in nature, then you need to disclose that information as it relates to Texas headquartered companies. That was recently held up in a lawsuit so ISS and Glass Lewis both sued, and they were successful in getting it halted, at least for now. So it's interesting. I mean, and they were making some allegations that are sort of First Amendment justifications that you can't be forced to state certain information that you don't necessarily believe in. So it's an interesting development, and I think that this is kind of part of the macro ESG pushback, where there's the view that the large institutional investors, led by the proxy advisors in large part, were driving kind of these societal kind of political outcomes through some of their vote choices. And so that has been an interesting development that we'll see how it plays out.
If a company was to re-domicile in Texas, Robert, how do you think that would change the litigation strategy?
I mean, as far as stockholder litigation and fiduciary duty and deal litigation by stockholders, I mean, it's going to be heavily, heavily circumscribed. We haven't seen many of those cases since the Texas business courts opened a couple years ago. And I think that has been the plaintiff's attorneys making a cost-benefit calculus as to, does this make sense to take on a contingency fee? And they determined that it hasn't. And that's only going to be more severe now that this year in May, Texas enacted some revisions to its business code that made it even more friendly to controllers and directors and officers. So, for example, they put in a statutory business judgment rule, which effectively it's very similar to what you see in Nevada as opposed to Delaware insofar as it can only really be rebutted by a showing of intentional misconduct. So anything reckless is not going to be enough. Grossly negligent is not going to be enough. Conflicted transactions aren't reviewed unless you can rebut that. And so that just makes suits very, very difficult. And even if you thought you could bring such a suit because there was a conflicted transaction, they put in pathways that you can seek a court's imprimatur pre-transaction of a special committee and its independence. And if the court agrees that it's independent, that's dispositive. It's unreviewable after that. And then, I can go on. They modified the books and records rules such that you can still get books and records as a stockholder, but not if you're doing them for litigation at all. So there's no, largely, 98% of the books and records claims that I see in Delaware are pre-litigation books and records demands. Those aren't allowed in Texas anymore. They've limited standing to large stockholders in most of those kind of suits. And then, one of the bigger issues with Texas, one of the question marks that people had as well, under the Texas Constitution, parties are entitled to a jury trial. And so one of the reasons that Delaware is so efficient in such a good form is they don't have jury trials for these kinds of cases. They have very sophisticated judges that can handle these cases. And what Texas did to get around that is they statutorily said that companies may put into their charter a provision that waives jury trials for stockholder litigation. So you've got rid of a lot of, the obvious impediments for controller-led companies to move to Texas. And really, I think it's just going to be a major, many companies may move there, but there's not going to be a lot of stockholder litigation that follows. And obviously it's debatable whether that's a good thing. I tend to think, and I think that the panel's already discussed it some, that I don't think there's going to be a huge exodus. I think just the status quo bias of companies that are incorporating are mostly going to still want to incorporate in Delaware because that's what sophisticated companies have done, and there's not a huge reason not to do it. I don't think there's, a lot of companies aren't thinking unless they're thinking they're going to do a lot of controller transactions that they're going to be violating their fiduciary duties. And I think similarly, existing companies aren't going to reincorporate at a rapid clip. So I don't see an immediate move. I think this is something to watch for 10 years down the road, how this plays out, but I don't see an immediate change in where people are incorporating.
Thank you. So shifting to our last topic of the evening, wanted to chat a little bit about proxy advisors and technology more broadly. Anyone have any comments on any recommendations out of Glass Lewis and ISS this past year, or given the changing personnel and staffing, or trends, or what they're prioritizing?
Well, as somebody that is always on the company side, I must say, I find some of the reports to be slightly slanted, pro-activist. But look, I think that continues, and as we advise our clients, it's always going to be an uphill battle. We often say, if ISS is going to be challenging, we need to get the passives, and a lot of times those two constituencies roughly offset each other. I think the new person at ISS, has been there for a long time. It's not, a new outside perspective and whole different way of doing things. I think it's continuing the same system that Cristiano had to a large extent, but we shall see. I think there weren't as many that went all the way to a vote and had recommendations this year. The one I worked on was the Phillips 66, the first one that Elliott took in the U.S. at least, all the way to a vote. And if you read those ISS and Glass Lewis reports, you'll see where I'm coming from.
And for anyone who's questioning, how did the vote end up?
The vote ended up in, it was 2-2. So Elliott got 2 seats. We got 2. The proxy advisors were very much in favor of the Elliott slate, and the passives went entirely with the company. So that kind of bifurcation worked out okay.
Yeah, I would just also say, like, there has been I would say a trend that is probably statistically significant, that there has been a change where ISS is probably a little bit more activist friendly this year versus last year. And maybe Glasslewis is a little bit more incumbent friendly, but it's probably marginal. I do think that is just a trend to watch. What I think will be an interesting development, and maybe Francisco has a view on this, is just given the technological advancements and AI, for instance, I think it could change potentially how investors are even using some of the proxy advisory work product, because a lot of the reason that they are so valuable is they had deep analysis of every company and they're doing the work for you. That may change a little bit, and I could see that some of the models of the institutional investors kind of being plugged into some of the AI tools could potentially change the demand and the influence of them. So, I mean, that's me sort of looking in my crystal ball, but just the world is evolving so rapidly that I could see how that could potentially change dynamics.
I think John is referring to a recent article that said that AI can now predict up to 80% of ISS and Glass-Lewis recommendations. So love to get your perspective on this, Francisco.
Yeah, no, it's interesting, right? As the models get stronger, as people get more savvy in how to use AI properly, I do think you're going to see instances in which institutional investors are like, I can figure out what ISS Glass-Lewis is going to say here just based on what they've done in the past and crunching the numbers and looking through it through the AI glass. But also B, and more importantly, is like, I'm just going to pull my own information. I'm just like, I have all this data, all the data is publicly available. Why can't I just work with it? So I do think AI is going to change the realm. It's going to be interesting. It's funny. I still haven't seen a lot of open discussion of how the activists, how the advisors, how the issuers are necessarily using it in this space. I'm sure everyone's thinking about it. I think the other interesting trend that's going to happen during this coming year on the proxy advisors is like we already mentioned, right, the attack in Texas. But more generally, I think they're going to be a little more defensive as to how they approach particular recommendations on the ESG side.
Yeah, I think there's definitely probably a retrenchment just generally towards G. That is a safer space to be prescriptive about. And then if you look at like the proposal landscape over the past year, the ENS support fell way down, and the numbers were relatively higher. I think that there's some changes as far as like how you can exclude a proposal under Rule 14M. It's a little bit more technical than I want to get into, but that is going to change the dynamic going forward. But I think G issues, governance issues, are kind of the traditional place for the activists, and the companies can probably lean back into that a little bit more. And so one should just be cognizant that I think the activists, the proxy advisors, are going to be more hyper-focused on, do you have good governance in place? Are your directors overboarded? Do you have the right board that's fit for purpose? They're going to be focusing on those because that is sort of the prophylactic measure that a company should be really introspective on to avoid an activist sort of poking holes at that and using that as leverage in a campaign, saying you need to make a change for financial reasons, but also you have like a director who's been on the board for 25 years. I think that those are things that are going to probably change the game. And so that is an ISS and Glass-Lewis issue for sure. I think that AI is going to probably accelerate some of that, but I think the macro trend is just going to be G is where people are going to be playing, and companies should be cognizant of that.
Well, and I think that the recent report that Vanguard supported 0 ENS proposals this past proxy season shows exactly just that.
Yeah.
So, well, that's all we have. I have a couple more questions, but if there's any from the audience or in the chat, I could defer to those first.
Yeah, I can start. So I think, look, I think it's widely anticipated, so you could effectively call it kind of priced in now, and people are already taking that into account. But you know, a lot of these things, once they happen, it catalyzes further moves, and they may indicate what they're going to do going forward. I do think that you know, while the financing market from a ability to access credit and debt instruments has been fine this year, rates are high. So I think especially as it relates to sponsors thinking about how to get their returns in a highly levered LBO kind of deal, I think rates moving down will be materially impactful. And I think we've already seen, you know, the 10-year, for example, come down from close to 5 to ticked under 4 for a little bit today. And that's already driving a significant change in that.
For the people watching online, that the question was about rate cuts and how that's going to affect the upcoming activist activity. Thank you. Did anyone else want to comment on the?
Yeah, and going to what we said originally, because there's going to be a further expectation of more M&A, I think the activists are going to continue to make the push for M&A, whether it's on the carve-out space or outright sales of the companies.
Yeah, and especially, you know, when it comes to pushing for some of these, you know, strategic review processes, essentially running a sale process, one of the issues has been a lot of our clients, it's very clear there's like, you know, one potential buyer. And then that buyer will have something, they just did a deal, they got some kind of tariff situation going on, who knows, but that buyer is not in a great position to do the deal. And if you don't have a robust kind of group of interested parties, you're not going to maximize value. You're not going to get a good price. As rates come down, you potentially have an elevated sponsor bid that can compete with whatever the strategics are that are in this process, and you end up with much, much more robust processes. Because one of the dynamics we're seeing is that the companies that do run these processes, where, you know, it might be 4 parties in the final round, you know, a couple of years ago, we're down to 1, maybe 2, and we're kind of, you know, having to do smoke and mirrors to get them up and to get them negotiating with us, because they kind of start to sniff out that there isn't a big process going on.
Anyone else? Okay, well then I will finish up with one final question, lightning round, if you will. We've heard a lot today. If you could give your clients one piece of advice, what would it be for the upcoming proxy season? If helpful, I can start. So I'll give you guys a couple of minutes. I just wanted to make sure that our clients are out there making sure their narratives are succinct and they're getting the correct messaging across. Because I think given what we've heard today, it's more important than ever.
I would say this follows on something John said earlier that I totally agree with. I think it is this whole be your own activist and be proactive. I think too many companies we see are sort of thinking about doing some stuff. They run the vulnerability assessment. They see where the attacks are likely to come. They even do the preparation to say, oh, how would we rebut this attack? And you put all this stuff together. And sometimes it's like, maybe just do that, right? Some of these actions are going to be what your shareholders want. And eventually when the regular shareholder base wants something, eventually the activist shows up. So I would say, don't do things you don't want to do just because you're afraid of an activist. I'd never advise that. But when something is pretty clear and you're hearing it from your shareholders, really take a hard look at maybe making that move.
Yeah, a good idea is a good idea regardless of where it comes from. So adding to that is like continue to engage with your shareholders, both the institutional shareholders. If you get an outreach from an activist, if you're ready, hopefully you already have like you have already self-assessed, you already have your communications in line, but engage with them, like be proactive and try to be collaborative.
I mean, my response is pretty similar to that. I mean, going back to the point that I made earlier, make friends when you don't need friends. It's incredibly helpful there's kind of a fog of war. When you're in an activism situation, like it's very helpful that you're not having a conversation with the shareholder for the very first time, or they're meeting your lead independent director for the very first time. Have those conversations when you're not dealing with just the absolute like froth of everything that's going on in an activist situation, and these are people, both the investors and the stewardship teams, they're people who want to like have an interaction with another person, and so they're going to be very receptive to hearing a little bit about how the board is thinking about things, how they're thinking about refreshment, how they're thinking about strategy. Have those conversations in peacetime. Now, again, to the point that I made earlier, that is going to change because I don't know that you're going to get the same level of two-way dialogue, just given some of the changes with 13G and 13D, but still have those conversations because your institutional investors will take those meetings, have those meetings, just start making introductions and get to develop rapport with them.
Yeah, I mean, at the risk of being redundant, I mean, I do think it's the best advice, kind of what I said earlier. It's preparing in peacetime, you know, and from my point of view as a litigator, it's when measures are taken in wartime, the scrutiny goes up a lot. And so if you just make it a regular part of your business to think about these situations and what your governance documents look like, and are you ready for anything that may come, you're going to be in a lot better position than trying to enact them later, even if you would enact exactly the same provision.
Thank you. Great advice all around.